Hello, everyone, and a very good evening to today's Immortal India series on webinar on a very interesting topic on digital evidences. So, today we have a really special guest with us. He is a really very famous personality in the legal fraternity. So, please welcome Ms. Tanveer Ahmed. So, talking about Sir is a practicing criminal lawyer for the past 22 years, and his office is at Defense Colony, Delhi. Sir is also a founder partner of firm Lex Alliance. Sir has successfully defended the accused in cases like 2G Spectrum, Arushi Talwar Hemraj double murder case, Ryan School murder case, Augusta Westline scam case, Coal scam. Sir has also defended Gurmeet Ram Rahim in Dera Sacha Sauda in the sedition case. Sir is a defense counsel for corporate lobbyist Deepak Talwar in corruption and money laundering cases. Mr. Meir specializes in white collar and serious criminal defense. Sir specially induces development overall strategies, conducting cross investigations for mounting the defense for accused and handling the trial, as well as appeal in criminal cases filed under Income Tax Act as well as Black Money Act. Sir further specializes in advising clients in matters relating to money laundering under PMLA 2002, Customs Act, and indictments instituted by federal law, investigating agencies like CBI, ED, SFIO, and GST. Sir, a very warm welcome on behalf of Immortal India. Over to you, sir.
Thank you very much, Ahmed. And I hope that my voice is clear and you're able to hear me, and people who have joined are also able to hear me. So I believe that you people are from Calcutta and you're studying in a university there. So that's great. So first of all, thank you very much for inviting me, and I would also like to thank people who have joined this platform and today on an interactive session on the topic digital evidences in criminal prosecution or civil litigation, as the case may be, because the law of the evidence at the end of the day remains same in whatever disputes may be adjudicated by a court of law. So I will, divide this session into two parts. So one is that I'll talk about my experience of handling some sensational or not so sensational cases and the role of digital evidence in all such cases. And then the other round I'll keep for a very good integrating interactive sessions where any and all of you, whoever are willing to ask any kind of questions regarding the evidentiary law or anything relating to practice and anywhere in India, the questions from any scope, any spare are more than welcome. That's why these platforms are necessary. And I'll also say that as a counsel, having practiced law for last 22 years, I'm also under a duty obligation to share my experiences with all young lawyers, law students, budding lawyers, so that I can pass on to you what I have learned from my experience in a hardcore criminal trial litigation for last 22 years. Because best knowledge is shared by experiences and what we learn in court. So first come first, let's understand what is the basic fulcrum, of any criminal litigation, be it a criminal trial for any offense, serious offense like murder or rape or dacoity, robbery, coming down to economic offenses and special laws, cheating, breach of trust, forgery of documents, and now you have a lot of special acts, criminal litigations like the Money Laundering Act 2002. Then you have the Companies Act, which SFIO prosecutes, against corporate concerns in white collar crimes. You have GST related crimes, tax related crimes, tax prosecutions, Black Money Act, non-disclosure of foreign funds, foreign assets, leading to criminal prosecution. So I think in about last one decade or easily about last 15 years, the significance of documentary evidence in the terms of electronic evidence has uh, taken the center stage in all criminal trials. Now, gone are those days, when murder cases would be solved by, arresting the accused and putting them to the sword of, third degree torture and custodial interrogation and, extracting and extorting confessions out of them and linking, evidence here and there and, then filing a charge sheet and leaving to the court. Now a lot of crimes, get resolved, get investigated, charge sheets are filed, criminal prosecutions are put into practice on the basis of electronic evidence. Digital evidence, at the end of the day, is nothing but electronic evidence. So the role of electronic evidence, in the Indian trial scenario, be it civil law, be it criminal law, is not something new, but some serious amendments were made by the legislature in the year 2000, and I think those amendments received an official assent and were published on the Gazette on I think 17th October 2000, like incorporation of Section 65B in the Indian Evidence Act, as far as proof of digital documents and electronic evidence is taken into consideration. Similarly, the definition of evidence in under Section 3 to include all electronic evidence so that the electronic evidence can be proved and taken to a logical conclusion in a court of law. But to a very large extent, for example, CBI prosecutions based on Prevention of Corruption Act track cases are always bedrock on electronic and digital evidences, because ultimately, in a case of corruption under Section 7, if some public official is demanding a bribe and he's to be tracked, it is essential that the complainant is given a digital recorder and he conceals it somewhere. Then you have two shadow witnesses. The essence of that investigation is that when the conversation takes place between the public officer and the complainant, as the case may be, the conversation gets recorded, and then that recorded conversation, if the demand of the illegal gratification or bribe is made out, and then the public officer can be nailed, in a court of law. So digital evidence goes back, the first judgment ever on whether a tape recorded conversation at the end of the day would be admissible in a court of law. So we go back to a famous judgment of A.R. Malkani, and the Supreme Court there very clearly said that yes, a tape recorded conversation would also be admissible in a court of law, but subject to certain safeguards. And what would be safeguards is that any tape recorded conversation, you have to have, first of all, it has to be played in a court of law fully, and nothing is to be concealed. It has to be cleanly and purely audible. The court must hear what the people conversing are talking about, and then there should be a forensic investigation also, and which should certify and provide a guarantee to the court that what is being presented in the tape recorded conversation or electronic evidence is not free from tampering, it is not free from excision, it is free from overlapping or anything, what can be done in order to further piece of evidence to work. Then the court can say that yes, this evidence seems to be strong evidence, it seems to be cogent evidence, it seems to be convincing evidence, in order to draw an inference based on that or to reduce it into finding. So for a considerable period of time, the tape recorded conversation was virtually the bedrock of electronic evidence in 70s, 80s, going up to 90s, and the requirement of digital evidence, and its role in criminal trials rose anything with the march of technology, with the march of internet, and therefore you had a requirement of calling into play of incorporation of the Information Technology Act. Now you have web domains, Facebook, WhatsApp, Google, and people are exchanging notes, people are conversing on these platforms. Then sometimes there is a WhatsApp conversation or a Facebook conversation, or you load something on the social networking websites, and tomorrow somebody says that, sir, I have this evidence in my hand, and I want the cops or law enforcement agencies or a court of competent jurisdiction to act upon it. And that's how. So therefore, with the march of technology, with the march of internet, with the march of bandwidth, with the march of technology, we have now a totally different guideline. We are virtually inundated now with evidence which is purely digital, and taking into due and consideration the government of India way back in the year 2000, incorporated section 65B as to how a piece of digital evidence will be proved in a court of law, how the prosecution will prove it or the defense will prove it at the end of the day. And correlated legislation was Information Technology Act. So the march of technology continues. Technology becomes sharper. So the requirement is that the law is also has to keep a pace with the march of technology. So if we see Section 3 of the Indian Evidence Act, very simple. Now, what is evidence in a court of law in a criminal trial or a civil trial is very simple. That any person who a court permits to step into the witness box, take an oath, and give an oral narrative, yeah, and then make himself available for a cross-examination is oral evidence, and that is evidence which is admissible and can be taken into contemplation by a court of law. Then the other kind of evidence which is acceptable to a court of law, whether you are in New Delhi, you are in New York, whether you are in England or anywhere in the world, is a documentary piece of evidence. Now, the amendment in section 3 in the year 2000 said that documents will include electronic evidence. What is electronic evidence is defined under the Information Technology Act. Means that wherever there will be a system source of a computer, or some electronic base will be there, some database will be there, there will be some data packets which when interpreted and brought before a court of law in the form of voice data, in the form of printed data, written data, can be acceptable subject to the party so asserting that piece of evidence going for a full compliance as is provided in the act. So how do you prove now a documentary evidence in a court of law? So the primary chapter starts from section 60, and no document is proved before a court of law is admissible if it is not brought in original. That's what section 62 of the Indian Evidence Act is all about, and electronic evidence is not an exception. So if, for example, you want to bring a letter written by me to you, or some other some document, you have to produce an original. Where the original is lost, or original is misplaced or destroyed, there is a fire, alpha, beta, whatever can be sent, then the court says yes, there can be secondary evidence as well in terms of section 63 and 65, and you can call secondary evidence if the primary evidence is not available. What happens when electronic evidence is placed into service? So electronic evidence is not an exception to section 62. Means that electronic evidence also has to be proved in a court of law in a criminal trial by the prosecution or the defense, as the case may be, by making an attempt and successfully convincing the court that this is an original piece of evidence and it's not a secondary piece of evidence, it's not a photocopy, it's not a duplicate, and therefore it is reliable, it is believable. Now, what is an original digital evidence at the end of the day? Like in the case of a correspondence, a letter written by me to you, you to me, I am, one of the parties will be in possession of the original letter. You can present it to the court and you can say that, sir, I am the author or this person is the author. Then the author can come as a witness and he can take an oath that I wrote this letter, and then that document can be exhibited and can be acceptable to a court of law that yes, this is a piece of evidence. Now, digital evidence, how, why? It's very simple. For example, I just pick up my mobile phone and I'm showing it on the screen, right? So if I I have a conversation on my phone tomorrow with any person and I record this conversation, and in this conversation tomorrow, whether in the hands of prosecution or defense, by any stretch of imagination, is needed to be placed as a piece of evidence to prove a particular fact. How do you go about that? How does the prosecution go about it? Is that, first of all, if the primary evidence is available. Now, what would be a primary evidence and what would be secondary evidence? So, if the conversation is recorded in a mobile phone, the primary evidence will be mobile phone itself, which means that any party wanting to prove the digital evidence in the form of a tapped conversation in an iPhone, in a Samsung, or whatever, by any mechanism, has to give this phone to the investigating authorities if the investigating authorities are investigating the case. If it's a complaint case, if you are prosecuting on your own, then you have to place this phone before the court as a piece of evidence. And you have to then say to the court that this is the primary evidence and I want this to be exhibited. I want this also to be sent to a forensic expert in order to determine whether the digital evidence covenanted in it, be it a conversation, be it a video, be it something else, is free from any kind of tampering. You see, at the end of the day, the biggest challenge in electronic evidence is, you know very well, that now there are so many softwares like Photoshop, those old days. Photoshop is quite old days. The biggest problem in electronic evidence is the dependability on the electronic evidence, because it is very prone to accession, to overlapping, to chopping somebody's head and imposing somebody's head on the body. So therefore, Supreme Court time and again, courts of law time and again, and legislature is trying also to smoothen the activities so that whatever digital evidence is got, it should be unadulterated. It should be free from any kind of overlapping, etc. You can use many words. So what happens is that, first of all, if, for example, the state is prosecuting, it is imperative for the investigating officer to seize the primary evidence, which may be a mobile phone, it may be a computer, it may be a hard disk, it may be anything else, it may be a printer, anything, anywhere, anywhere. The next step is that once they have it, they have to seal it and send it to a forensic laboratory. Why do you send it to a forensic laboratory? Let's say, for example, CDFD Hyderabad, CFSL Calcutta, CFSL Delhi, in order to determine that whether that evidence, which is in the nature of a conversation or a video or otherwise, whether that evidence has been tampered, altered, or anything has been done. Because even if an iota of some altering has been done, then the evidence is done and dusted. The court will never look at it, and it can never be depended upon, can never be cogent and convincing evidence at the end of the day. So you produce it in the original, then you get a forensic examination, and finally you seal it again. The forensic laboratory will seal that evidence. It will go back to the cops, maybe the CBI or any police station, and tomorrow when you file a charge sheet, you produce that evidence during the course of the trial to be seen, to be exhibited, to be played, to be opened before a court of law. Now, for example, if the piece of evidence is a conversation stored in a mobile, and the cops have sealed it, the forensics have also examined it, they've taken a mirror image, they've operated it, and they have found that this evidence is fully reliable, it has not been altered, it is resealed, it is opened in a court. In a court, this evidence again will be inadmissible unless and until, before a court of law, this evidence is not played end to end. So court has to see it. Say, for example, if there is a conversation, court has to hear the conversation. So court will ask the court staff or the lawyer or the prosecutor or the expert, whoever he is to play the conversation or play the video. and once it is seen, it will then be exhibited, and then the expert or the evidence will be there up for cross-examination by the defense, as the case may be. Now, the problem sometimes which the courts face is that sometimes the primary evidence is not available. Now, for example, sir, what do we do when something is on the Facebook? How do you now get the Facebook evidence, as a primary evidence to a court of law? So what you do is that if you were accessing the Facebook, say, or WhatsApp through a computer, then you are under an obligation first to have those computers in original sealed and brought before a court of law after having a forensic examination. You then seek a corroboration from the company which runs the platform, that whether according to them, if somebody has a Facebook account, somebody has a WhatsApp account, somebody has a Twitter account, somebody has some other account, whether that person indeed has that account, or it is that somebody has opened the account fictitiously in a different name. So you have to have corroboration from the social media companies, people who run these platforms as well, in order to have that evidence before a court of law and in order to enable the court to rely upon that. Now, that kind of dependability is there for for the court to rely upon it. It is very essential that any person who asserts this evidence takes these precautions. The biggest problem in Indian scenario is, yes, what happens is that cops come and they say, all right, you give us a pen drive, but they don't ask for primary evidence. By that time, sometimes a person has lost his mobile, but he transferred the file in another mobile or into a computer or three other computers, and then they sometimes say that, okay, you give us a pen drive, and they take the pen drive, and then they sometimes don't send it to a forensic, sometimes they send it to a forensic, and tomorrow when they come to a court of law, I will ask as a defense counsel only one question: sir, have you proved the primary evidence before a court of law or not? So they'll say, all right, कि साहब ये जो पेन ड्राइव है आपने कहाँ से लाई? कि सर हमको तो पेन ड्राइव कंप्लेनेंट ने दी। जी ये पेन ड्राइव जो है ये कहाँ से कनेक्ट हुई थी? ये साहब किसी कंप्यूटर से हुई थी। भाई आपने वो कंप्यूटर सीज करा नहीं करा? नहीं सर हम तो भूल गए। अच्छा जी तो वो कंप्यूटर आपने देखा था? जी हमने देखा ही नहीं। So in that scenario, the electronic evidence gets busted and dusted there and then. Court says, get out. This is not the evidence I can choose and I can rely upon. So these kinds of problems, teething problems, are there everywhere in India, whether in metropolitan cities, tier 2 cities. The courts actually, even in federal law investigating agencies, they have to be given special training, how to preserve electronic evidence, how to get forensic evidence before a court of law when it is electronic evidence. Most of them don't know what's happening. Sometimes they'll get a CD. Sir, CD mil gaya. The CD kya hota hai? CD is nothing. Unless and until you don't get me the primary evidence, how can you believe on a CD? So therefore, even if you send a CD to forensic, the forensic may say that, sir, yes, it seems to be what is there is correct, but I can't certify it because I have not seen the primary evidence. This is equivalent to a situation where you send a photocopy of a letter or a handwriting sample to a forensic. He says that this photocopy looks like the handwriting of the writer, but I can't certify because I have not seen the original. Maybe somebody just copied. That is why the photocopy evidence or secondary evidence is always inadmissible before a court of law, lest primary evidence is brought. So similarly, one is under an obligation to make best attempt to get the primary electronic evidence before a court of law, one, by producing the primary, and secondly, by having a forensic verification of the primary evidence. Then it becomes a double whammy for the defense. It becomes very difficult for the defense to dislodge that piece of evidence at the end of the day. Similar obligation is on the defense counsel as well. So if the defense counsel tomorrow wants to prove electronic evidence, he has to follow same procedures. The only exception, where electronic evidence says in digital evidence, where courts of law, don't press for primary to be produced in court of law is where primary cannot be produced. For example, when we talk about all detailed records. Now, all detailed records ultimately are, stored originally in a digital format in huge servers. Like if we talk about telecom operators like Airtel, Vodafone, or any other company, Geo, Reliance, these people have their servers based out of Pune or other places, and there are huge servers. They are in big buildings. So those servers can't be brought to a court of law. That's why Section 65B certificate is called for, where a person, has to testify that, sir, I have the code to the digital storage devices of the servers available with me. I punch those codes and I get a direct access into the servers. After applying applying the code on a specific designated software, I get the product of a call detailed record of a particular number on a printout, and then he writes a certificate that I am authorized by this company to give this certificate. Why? Because I am enabled by the company to have the codes by which I access the computers. My computers during the relevant period of time were working properly. There was nothing wrong with them. Everything was being fed into the computers on a day-to-day basis without any break. And he has to also give description of all the hardware and the software that he has used. Then the court of law says that yes, now we have a certificate under section 65B of a piece of electronic or digital evidence which can't be physically brought to the court, therefore it is acceptable. So that, at the end of the day is, how digital evidence in terms of section 62 of the Indian Evidence Act and 65B onwards is to be proved. Now, coming back to how the courts have dealt with it, the courts also have been in dilemma. So the amendment and requirement of any digital evidence having to be mandatorily complied in terms of section 65B was there right from 17th of October 2000, but prosecution, state prosecutions, cops, CBI, federal law investigating agencies, DRI, narcotics, everybody was oblivious to this mandatory declaration and the command of law. And what they were doing is write a letter to a telecom operator. He was sending, a CDR by email. Then the cop was taking a printout, and tomorrow, he was throwing it in the charge sheet. And he was himself, coming and testifying and say that, sir, I will prove this digital record or this call detailed record. How? Because I wrote a letter to Airtel company. He sent it in my email. I took a printout, and here I am. And that's how things were working. And that's exactly what happened in the landmark judgment of of Parliament attack, where the Honorable Delhi High Court and Supreme Court said that even if Section 65B certificate is not there, and the Airtel witness or the system operator or the telephone authorized representative has not testified, let us also believe the IO, because according to their opinion, as far as electronic evidence and particularly the CDRs were taken into consideration, it could also be proved by secondary evidence. Means that if the company authorized representative did not come, but cop proved, thank you. And that's how it went. Till 2014, when a three judges bench, was contended with an election, dispute and a CD, again, no primary evidence. So they applied their mind. They had a look at the legislative intent and the content of Section 65B, which is an elaborate provision, and they returned a categorical finding that, boss, this 65 is a comprehensive code for electronic evidence, and you can't prove electronic evidence by secondary evidence. What is secondary evidence? For example, let me give you a simple example. If primary evidence is a document, means a letter written by me to you or anybody else, that's being destroyed in a fire or an agreement to sell. So what does a lawyer do? A good lawyer who knows trial law. He says, sir, I am not in possession of an original. So I'm getting an application under Section 65 of the Indian Evidence Act. I make a declaration that I'm not in possession of the original. Allow me to prove this evidence or execution of an agreement to sell or a contract by secondary evidence. The court says, how will you prove? Or he says that, sir, the people who executed and people who were witnesses hold an eyewitness account that yes, this was the document to which the parties affix their signatures, they executed these documents, so I'll call them for an oral evidence. Court says, very well, permission is granted, you have made a declaration, now you need secondary evidence in terms of 63 and 65 of the Indian Evidence Act. But in electronic evidence, in Parliament attack or prior to those judgments, the Supreme Court was saying even for electronic evidence, you can get a third party to testify. That is where the Supreme Court negated this proposition and they said that 65 is a comprehensive code. You cannot prove electronic evidence by a third party testimony. So therefore, if it is electronic evidence executed by me and you in terms of an electronic gadget which is movable, which can be brought to a court of law, which can be handed over to a forensic, then be it. If you don't get the original, which is primary evidence, then secondary evidence, you cannot say that, sir, yeah, look, I was testifying, I was talking, and this thing got recorded, and I don't have the original phone, I only have a CD now, and so this is clean. So court will say, thank you very much, we can't trust the CD in in the absence of an original. And the only exception is that where the original is not in a position to be brought by the court, so you have to, then in that case, if you are producing a CD or a pen drive or anything else, you have to then append the Section 65B certificate and comply with the requirements of Section 65B and leave it to the court that whether that pen drive, that CD, or that computer output would finally be accepted to a court of law. Now, let me give you some examples where the court, in some very serious and sensational cases, the courts threw the digital evidence out of the window. And why? Let's talk about a very famous case in Delhi where a former DIG of Punjab, of Haryana, by the name of Mr. R.K. Sharma, was a principal accused in a murder of journalist called Shivani Bhatnagar murder case. So the trial was held before Dr. Rajendra Kumar Shastri in Delhi. Dr. Shastri convicted everybody and also held the electronic evidence, which was some CDRs between various accused because there was a conspiracy and people were talking. So you had digital evidence in conversation. You also had digital evidence in the call detail records. They were placed before a court of law. They were believed conviction was there. Up came an appeal before a division bench. The division bench acquitted almost everyone. And they said that when we examine these call detail records, we see something very fishy. And what is fishy? We see that certain columns or certain calls are missing, and certain numbers and certain calls seem to have been added. So they hammered Delhi police for tampering of the electronic evidence and acquitted everybody in one blow on that time. The matter went to Supreme Court and Supreme Court upheld that judgment. They said, yes, this piece of electronic evidence seems to be subjected to some kind of tampering, so it would not be acceptable to a court of law. And that's how it happened at the end of the day. There are many other cases as well. So the Supreme Court also has been going through a constant dilemma of how to now handle those cases where there are so many large prosecutions, murder cases, serious crime cases, where there is no compliance of Section 65 2000 and effectively, which was the command of law after being published in the Gazette on 17th of October, the cops have not followed. And it seemed to me that electronic and digital evidences
Yes, sir.
Yes, Manav, am I live?
Yes, sir. You're audible.
All right, I think there was a minor glitch in between. So,
Yes, sir.
the three judges bench in 2014 declared the law that unless and until you don't strictly comply with the requirements of Section 65B, Section 3, Section 5 of the Indian Evidence Act, the digital or electronic evidence will not be admissible before a court of law. Then, since the problems arose on how to deal with prior cases, so there was a judgment written by two judges of the Honorable Supreme Court in a judgment which is called as Shafi Mohammed versus State of Himachal Pradesh. There they said, look here, all right, PB Anwar is very fine, we agree, but look, this is an evidence act and it's a law of procedure at the end of the day. And if you did not take specific objections, as the defense counsel sometimes lack, and tomorrow an inadmissible piece of electronic evidence is pressed into service by the prosecution, but the defense counsels do not object to the exhibiting of the same or placing it on record, then you waive your rights. So, again, it was reasserted that one has to be very vigilant during the course of the trial. That's what trial lawyering at the end of the day is all about. And finally, another three judges was incorporated, which has recently in 2020 delivered a verdict that is called as Arjun Pandit Rao. And in Arjun Pandit Rao, the Supreme Court has again, with complete authority, reasserted what was said in PV Anwar, that look here, as far as electronic evidence is concerned, you have to go with a strict regime. If there are prior cases where electronic evidence has missed the bus or you have not been vigilant, well, then you cannot hammer the accused or blame the defense counsel. You are yourself to blame. So they did away with Shafi Mohammed. That was overruled, and it was clearly said that whether you've taken an objection on electronic evidence or not during the course of the trial, if something is inherently inadmissible, like hear and say, somebody gives a testimony of complete hear and say, मेरा मामा ने मेरे को ये बताया कि उसकी चाची ने उसको ये बताया. Now, even if I don't take an objection and tomorrow, this is a part of the record, this is a part of testimony, whatever extent is hear and say has to be expunged from judicial consideration. So they have reasserted with complete authority the judgment of three judges in PV Anwar, and that's the law. Ultimately, why do we have strict compliance of digital evidence? Because digital evidence is so susceptible. Tomorrow on Facebook, you can, God forbid, have a nude woman and put up, head of your ex-girlfriend or some film actress or whatever, and you will run into a huge problem. And then how the court of law should be ruling on it. That's why production of the primary evidence is very, very necessary. Now, the last part would be today, is now the world of WhatsApp. Now India is all, when going through a phase of WhatsApp universities, and that's what people talk about. So there's a lot of, things on WhatsApp, social media. How do you now, prove a WhatsApp conversation before a court of law? Whether it's a case of prosecution or a defense, as the case may be, procedure remains the same. So number one is you have to get that primary mobile, the mobile in which that WhatsApp conversation is recorded. You have to place it before the investigating authority or the court, as the case may be. You have to have it forensically testified and verified. You have to get the platform to testify that yes, this is the number of this person and he's running a mobile and he has a WhatsApp account, he has a Twitter account, he has a Facebook account, and he's a genuine person, and therefore we can verify from our servers that this conversation has taken place. Then the court can rely upon. Lastly, what I'll say is that electronic evidence, primarily is not treated as primary evidence by a court of law. Electronic evidence till date, before any court in civil litigation, criminal litigation, serious crime trial, is supposed to be a corroborative piece of evidence. So what is the primary evidence then? For example, if I am relying upon a conversation, primary testimony will be of the witness that, sir, I talked. Who did you talk to? I talked to accused. Or what did the accused say? Accused said, it said, Your Honor, that I will do your work only you if you pay me 10 lakhs, or otherwise I will not pass your tender. All right. Now, did you record this conversation? Yes, sir, I recorded the conversation. How did you record? Sir, I had a mobile and my mobile was on a record mode, and everything I talked with the other person, I had a recording chip or a recording device. I had switched it on, so everything, sometimes some mobile phones have auto record. So everything that, that you talk gets auto recorded. For example, when I defended Kuldeep Singh Sengar in Unnao rape case, there was a person, who was girl's uncle. He had an auto record. So he had about 300 conversations of 1 hour each. So he came and testified and then, proved his conversations also in the same methodology. So today, you're seeing in Bombay that from some WhatsApp, people are being called and to join investigation. Yes, you see, the cops can call anybody, to join investigation under Section 160. It's a very simple language. If according to them, somebody is acquainted with the facts and circumstances, certainly can be called to join investigation. Whether arrested or not is something else. But in order to prove a case, for example, you consumed narcotics. Now, consumption of narcotics will not depend upon what you conversed on the WhatsApp. That will be the last piece of evidence which the court would rely upon. Court would like you to first get primary evidence to the court. Did you buy it? Where did you resource it from? Whether that investigation has been done or not. So solely on a WhatsApp conversation, the way people are now sort of getting lynched or lifted or arrested is totally obtuse. So, my friends, therefore, I hope that I'm clear and you have a better concept of what digital evidence is all about and how tomorrow you are to absorb digital evidence and you are to prove the digital evidence and how you are supposed to demolish digital evidences as well. In a court of law, if you are tomorrow a defense counsel, you will look first of all whether primary evidence has been got or secondary evidence has been got, whether the chain of custody is proper or not, whether forensic verification is good or bad or ugly. Like, let me give you an example. Recently, I'm doing a sensational suicide case out of Delhi, where somebody's wife committed suicide, and I'm defending the husband who is accused of abetting the suicide. Now, a bail application is filed, bail is granted, bail is challenged. We are in High Court. In the High Court, the girl's father files a petition and annexes certain WhatsApp conversations with it. But what he does is he, would select three pieces of the WhatsApp conversations and not put the entire conversation. So if I took a couple of defenses, that's whether this WhatsApp conversation as on date is genuine or not. How do we know? No forensic verification has been done. Whether this conversation has been put before the court in entirety, or you are taking two sentences out of the context in which the conversation was taking place and wanting to influence the court. That's how you demolish, a WhatsApp evidence when it is not brought before a court in the manner in which it is supposed to be brought. So therefore, my friends, that is what digital evidence today is all about. The guiding lines are Indian Evidence Act, Section 3, amended Section 65. Information technology is a repository of electronic evidence. Again, the way it is to be proved is very simple, not rocket science. What I said is the methodology. You can make a note of it, or you can call me at any point of time. I can certainly explain. I get a call from a lot of cops at some point of time. That sir, हमारी ये दिक्कत है, इसमें से बाहर कैसे निकले? So sometimes we are providing solutions to that as well. That's my friend all for tonight. So Manav, can we go to the question and answer round?
Thank you so much, sir, for a really informative session. Sir, before we go to the questions round, I would like to share something with you.
Yes.
Sir, when I was in class 11 or 10, sir, it was the first time when I saw you in a news channel like ABP News, where you were talking about the Arushi Talwar case. Like you were talking about some verdict, like what happened in the courtroom. You were talking about that, and my dad also talks about lot about you. Like my dad really likes the way like you interact, and I'm so really very happy that you are here with us today. Like it's a
More
really
than
happy moment for me.
more than welcome. I'm glad that you have followed the Arushi Talwar Hingraj double murders, where I went to Ghaziabad to defend the parents and conducted most of the cross examinations. Then despite getting a negative verdict, we did not lose any hope. We challenged the verdict in Allahabad High Court, and I personally remained in Allahabad for 4 months, argued the matter day in and day out. There were 5 lawyers in Allahabad, myself and another lawyer by the name of Mr. Dilip Kumar. We were the two lead lawyers arguing, and we had 3 assistant counsels. One is my own colleague, Mr. Dhruv Gupta. I had another wonderful lawyer called Aditya Vadva, and one Mr. Rajesh Gupta. So 5 of us fought that wonderful battle, and we got our clients comprehensively exonerated. Let me tell you, the Arushi Talwar double murder acquittal is not an acquittal on benefit of doubt. It's a case of comprehensive exoneration. But let me tell you what was the icing of the cake for me.
Yes, sir.
On 12th October 2017, I was at 2 o'clock or about 2:30 when the verdict was pronounced. I think the courtroom, which could have around 60 people, had around 400 people of lawyers. And the lead judge, the senior judge, Justice B.K. Narayan, was very candid, and he said that Mr. Mir, we certainly liked your work. And they said that the written arguments that you had filed in the appeal, which you had filed in the trial court record below, were most useful for us to write in writing the judgment. And 3 days later, I saw the judgment. I think about 70% of that judgment is simply taken from the written arguments that I had filed in the trial court. But I must also tell you that all serious crimes, all criminal cases, they are never won in appeal. You must remember, if you tomorrow, if some of you want to do a criminal litigation or civil litigation, now, and if you want to be litigating lawyers, it's very essential for you to be trial lawyers first. If you straight away go to Supreme Court or High Court, you will remain, and don't take it as an offense, you will remain quacks. You will learn nothing, because ultimately the art of advocacy and art of serious criminal defense, serious civil litigation is learned in the trial courts alone. So how do you win a criminal case? You don't win a criminal case in appeal. You win a criminal case only in the trial. And how do you win it on the trial? You have to win it on evidence. If you break a case on evidence and you have a very good cross examination, you won the case. You may run into a conviction machine. You may run into a very negative judge. You may run into atmosphere which is exploded, which is media highlighted, so much of pressure, and you may get a negative verdict. But you will get a reversal in High Court. You will get an acquittal in High Court. But you will only get an acquittal or high. You will not win in High Court. You will win only in the trial court. Let me give you another example since you touched this subject. In Delhi, there's a very famous case called teacher scam case of Chautalas, the famous Chautalas of Haryana. They were prosecuted by CBI, and the trial took place before a very famous judge called Vinod Kumar Saab. They got a 10-year sentence. They, engaged the legendary Mr. Ram Jethmalani in appeal, and for huge fee. Ram Jethmalani, even at that time, was 1 crore per appearance, easily, and which clients would pay very gladly. Mr. Jethmalani, I think, spent about 2 months continuous time in trying to, mend the damage or the inadequacies in the trial at in appellate court. He got a dismissal. So even a Jethmalani could not get a case acquitted because the case was not won on evidence. If you lose on evidence, you can never win an appeal. Ultimately, a criminal trial will be won only on evidence. In Arushi Talwar, I went to do the trial when 10 witnesses were already examined. So what did I do? I examined and cross-examined. I took the lead in the case, and I thoroughly cross-examined as the lead counsel from witness number 11 to witness number 39. Then, I got about 10 witnesses in defense. There were other things. I filed a 180-page judgment. There were two lawyers, asked. One was a civil lawyer based out of Ghaziabad called Satyaketu Singh. He had examined the first few witnesses, and remaining witnesses were done. So two of us worked on there, and five of us worked in the appeal. That's how we got that case. But ultimately, the victory in Arushi Talwar is a victory on evidence in trial court, not in the appellate.
So, sir, we'll move to the questions.
Yes. So, can you put the question asked people who are asking questions directly onto the screen, or you noted down the questions?
I'll read out the questions.
All right, read out the
Or,
questions.
I'm just showing one question, sir. Can you read? Just check once. Like I'm putting this question.
Okay, now this is Ronak Chaturvedi from Calcutta said, can WhatsApp messages be used as a cause for gross criminal instigation in the court? I couldn't understand the question. What does Ronak want to ask?
He is asking like you have also mentioned. He is asking basically about the WhatsApp messages. What is the applicability of the WhatsApp messages as an
I
evidence?
already said that the WhatsApp messages certainly will be in the domain of admissible evidence, and you can use them, for the purposes of prosecution, for the purposes of defense, which means you can use it as a defense document as well. But you need to, prove your WhatsApp messages in accordance with law. So you have to get your mobile phone to the court. You can't rely on a pen drive if the mobile phone is available, correct? And if you don't have the mobile phone, then you have to append the certificate. You have to convince the judge that this is something, which is admissible, and then use the conversation for the purpose of cross-examination. Like how would you, for example, ask a बहुत ज़्यादा case होता है, a lot of cases hit our rape courts. So what happens? Boy falls in love with the girl falls in love with the girl, with the boy, and tomorrow there is talk about marriage. Marriage falls apart, and suddenly there is a case of rape on failed promise to marriage. The girl lands in the police station. The boy lands in the jail. Now the boy's lawyer, the boy later says, "Sir, there is a WhatsApp. What is on WhatsApp? Sir, the girl says to me on the WhatsApp every 3 minutes that I love you, or the love of my life." All right, very nice. Now, how will you? So when the girl will come to testify, you will get your evidence and you will confront the girl. Yes, sir. आप WhatsApp message लिखते थे? Were you doing a WhatsApp conversation? Yes, sir. I was doing. Or if she says no, I was not doing any WhatsApp conversation, then you will say you're right. You see, this is the WhatsApp conversation. You're deliberately today not wanting to admit it. So that is how we will proceed on a cross-examination. So WhatsApp, Ronak, will be admissible, but you have to take care that you have to get that evidence in a pure form to the court. Tomorrow, you should not land in a position where court says that, look, you've not complied with the provisions, so I am throwing the WhatsApp into dustbin. Next question.
So this is the next question.
Rajesh Sharma says, if screenshots of WhatsApp messages are submitted with a certified, will that suffice as a proof for original device is still to be submitted to the court? Certainly. Wait, now it's an interface on an interface. So which means that WhatsApp conversation, you have, for example, you do a scan code and you can start your WhatsApp on your laptop. You can start your conversation, on a desktop as well. When you take a picture, correct? Now you have a WhatsApp, you have a picture. You've taken a picture in a mobile or a digital camera. You will have to get both primary evidences to the court of law, my friend, and prove them in original. If you burn them, destroyed them, or go gaye, niche gir gaye, toot gaye, then 65B can be called into play. Now, you see, any evidence can be got to a court of law. Ultimately, you have to convince the court, before relying upon a piece of evidence, wants to satisfy whether this evidence is cogent, convincing, and reliable. These are three simple things. If you don't, comply with the requirements of proving an evidence, court will say it is not reliable and throw it out. If you prove it in the right manner, court say, all right, this is reliable, I will act upon it, I will receive it, And tomorrow, if I find that a covenant of this piece of evidence is incriminatory, I will write a conviction, or I will draw an inference or a finding against the accused on that one. You can certainly do it, but you will have to get both of the devices to the court in the terms and in the manner which I explained. Next question.
Yes. So this is the next question.
Correct. What is the remedy where police and central agencies submit false digital evidences in the court? Very important question. That's a very, very important question. So, whenever any digital evidence is brought to the court of law, it is very necessary for the keen eyes of a good trial lawyer to first see, whether the digital evidence is good, it has been tampered, so he has to make a very keen stand. Now, for example, if the digital evidence is a spectrogram, which means a voice memo, it is a report of a forensic scientist who says that, look here, sir, I have compared your voice and the question voice with a sample voice. And according to me, these are the talks and the voice of the same people. Then you have to have an expert in defense who will examine that whether the report or the digital evidence so presented is free from any count of alteration, any count of adulteration. And if he says that, look here, I'm not sure, and you can get him in defense, give a defense testimony, and tomorrow what does the court say? Weighs the two testimony, whether the prosecution expert was good or whether the defense expert was good. Both has to be seen by the same eyes and same scales. It's not that prosecution witness of a digital evidence will be on a higher pedestal than defense. No. So all will depend upon how you pursue a particular piece of evidence. Where an expert is required, the expert should be got, whether it is digital, whether it is DNA, whether it is ballistics, whether it is electronics, because ultimately it is only a diamond which cuts a diamond. As a lawyer, I don't have expertise of somebody who understands the physics of voice, who deals daily with these things. So I have to have a defense expert in defense if I want to demolish a particular digital evidence, as a defense counsel. That's your remedy. So, if false evidence, if your expert says that this is false evidence, you can file for perjury and take the corpse to cleaners. Next question.
So this is the next question.
All right, Chandrasekhar, in WhatsApp Messenger call, consider the message read as blue indication, but both have not enabled red receipt. The message doesn't turn blue. In such a case, how anyone can say that message read through delivered? Well, it's a good question. You talk about delivery. The point is not delivery. The point is that at the end of the day, whether a piece of evidence exists or whether you created something out of a digital platform which looks like it exists but actually it doesn't exist. So it's a kind of a mirage. So it's a wonderful question. I appreciate the question and the intelligence of the person who's asking. Is sometimes you can do, for example, you can plant an email, correct, into somebody's mailbox by that's why what you call as a secured network and an unsecured network. If tomorrow a hacker can march into a unsecured network and leave some evidence, and tomorrow cops will be saying that, look, you are talking to ISIS, thank you, sedition, unlawful activities act, remain in jail for next 30 years. आपको पता ही नहीं, मैंने कभी मेल ही नहीं देखी, न मैंने कभी वेबसाइट एक्सेस करी. So the man is as good as gone, and that's a very dangerous territory to get into. So therefore, the correct methodology for the prosecution is that if they want to rely upon this evidence which Chandrasekhar asked, they have to ask the forensics. Correct? The forensics must certify that yes, this message was sent. Whether you read it or not is something else. Correct? The question is, what message was sent and what is the significance in a criminal trial or a civil trial? At the end of the day, भाई आप एक आदमी आपको मैसेज भेजे जा रहा है, आप जवाब मत ही दे दो, कोई फर्क नहीं पड़ता. जो मैसेज आपके फोन पे आ रही है, उसकी क्या एविडेंशियरी वैल्यू है, वो तो एक फैक्चुअल नरेटिव ही उसको बताएगा। बात ये है कि साहब फोरेंसिक वेरिफिकेशन क्यों जरूरी है, इसीलिए जरूरी है। और अगर आपको लगता है कि साहब ये तो किसी ने हैकिंग एक्टिविटी कर ली, अब आप देखिए साहब, कभी कोई कहता है जी साहब ये तो जी आपके फोन में नंगा वीडियो मिल गया किसी लेडी का, वो कहता है जी मेरा तो फोन किसी ने हैक कर लिया, तो आपको वो साबित करना पड़ेगा कि साहब फोन हैक हुआ। So therefore, that's why does Supreme Court again in Arjun Pandit Rao go back to PV Anwar? बोलता है साहब ये इलेक्ट्रॉनिक एविडेंस तो इतना डेंजरस टेरिटरी है, ये तो समझ में ही नहीं आता, मैंने फोन खोला भी और इसके अंदर पता नहीं क्या कहां से आ गया। अब आप आज की डेट में जी आप वो जो आप देखिए आज बता रहे हैं कि साहब कई लोगों की आदत है सुबह इन द मॉर्निंग दे विल सेंड यू अ पिक्चर ऑफ अ फ्लावर। Now you know that picture of a flower has some unknown data which is stealing your data from the phone. So what I am doing is everybody who sends me picture, I am blocking him from my WhatsApp. So these are difficulties, but they have to be faced. So one has to be, you have to meet all these propositions with a strong sense of alacrity in a court of law or even otherwise, because you don't know what will happen tomorrow। आपकी वेबसाइट पे आपके ईमेल में कुछ आ गया, आपने बटन दबा दिया, पता नहीं क्या हो, आपको पता ही, और ईमेल कोई इनोकुअस सी आ गए, आपके तो साथ पैसे भी बैंक अकाउंट से निकल गए। That's what happens. So one has to then be very vigilant about all this and explain it to the cops at the end of the day, and the cops are also called upon to prove everything very very succinctly and sufficiently before a court of law, and not leave any doubts. Even if there is a single doubt, the court will throw it up. Let's have a next question.
So this is the next question.
Pushpak Kumar, WhatsApp status can be considered as evidence? If yes, how will be true? Now WhatsApp status is like you have a status of a magician on your WhatsApp or whatever. Well, anything that you do, you see, the WhatsApp has, I think, consumed our whole society. It's time to divorce WhatsApp and get into reality. You can't be inundated with your mobile phones. Tomorrow, all of us will get converted into wrecks. It seems to me that people are now more married to social media platforms than even their own wives at the end of the day. So yes, my friends, you can prove anything that is from WhatsApp, Facebook, anything, anywhere, within your status or something. If that is relevant before a court of law, very well, let the court of law receive it. But you have to make a strict compliance of requirements in law so that it remains admissible. Now, let me give you an example. Many years back, before NDTV, people once stung a cop who was caught red-handed outside Patiala House courts, accepting a bribe of 2 lakhs. He was dismissed on third day, and I happened to do his trial. When it came to trial 5 years later, there was a CD, and the camera was nowhere. So I just asked 4 questions, and the judge threw out the case. The man got acquitted. He's working in Delhi police again, probably asking for more money, double the money than the last time. So अब पहले जमाने में तो साहब जो है भाई बड़ा बड़ा कैमरा होता था, कैमरा भी छोटा होता। सो आई सेड सर प्राइमरी तो आएगी कोर्ट में, सीधे क्या पता नहीं कौन सी सीडी को मारा, इस पे तो आप रिलाई नहीं कर सकते, उसकी फोरेंसिक वेरिफिकेशन भी नहीं थी। सो कॉप्स यूजुअली स्लीप ओवर, अरे सीडी आ गई यही बहुत है, ठीक है जी इसी को चला ले, आगे पता ही नहीं कि जब वकील घुसेगा तो सीडी की तो बीड़ी बन जाएगी। यू मे स्मोक द बीड़ी ऑफ योर सीडी एंड थैंक यू वेरी मच। Let's go for next question.
So this is the next question.
Can a complaint be filed with police on online mode taken? Oh, why not? Why not? The Delhi Police Commissioner has emails open, and today, for last so many months now in coronavirus time, we're doing everything on email. So you can certainly file a complaint on email. ये जरूरी थोड़ी है कि थाने में जाके मोहर लगाओ, वहां पर पुलिस वाला बोलता है मोहर तब लगाऊंगा जब मेरे को 2000 रुपए देगा। तो आप डायरेक्टली ईमेल कर लीजिए, क्या दिक्कत, कोई दिक्कत नहीं, ईमेल का अपने पास प्रूफ रखिए। तो आज की डेट में तो हर जगह, हर ऑर्गेनाइजेशन में आप कंप्लेंट, पत्राचार जो भी करना है ईमेल के जरिए करिए। अब ये अलग बात है भैया, आप कोई बोलेगा सिर्फ हिंदी में ही लिख लो। अगला सवाल पूछिए।
Sir, this is a quite out of topic question, but he is texting this quite a lot of time.
How to make a transition off from an advocate practicing under a senior to an independent practitioner? So whenever you are ready, you see, you join a senior so that you get some exposure in a court of law as to how things are done in a court of law, how you argue, and how you draft, how you plead, how you conduct yourself. So anytime you feel that, look, I'm good, I want to take a plunge on my own, and I'm ready, so you do it. Why not? It all depends upon you. I mean, you should not be working under the senior for your whole life. Otherwise, you're not, made for lawyering at all. Let's have next question.
Sir, there are some questions given by my classmates. They
Okay.
have just sent it to me over here. Sir, one question is from here, like, sir, according to you, what are the crimes committed by juveniles these days are having impact at a country?
Yeah. See, juvenile crimes are on a huge rise. So I defended the 16-year-old juvenile class student who was just 16 years and 2 months in the Ryan Murder School at Gurgaon, that famous Ryan Murder, where the neck of a 7-year-old young student was chopped in the school, and the boy died. So juvenile crime certainly on rise. That's why you had Nirbhaya juvenile case, and there is the legislature has now said that, look, if the boy is 16 or the girl is 16, then he can be treated as an adult, and why not? And you have a strict regime because of transition. Early puberty, earlier. Now things have changed. So juvenile crimes, are on the rise. They have to be dealt with strictly. And though juvenile law is all about retribution, and or reformation, sorry, but as a society, you have to, if the juvenile crime in a country is on the rise, then you have to make laws to tackle the situation, because you can't have a juvenile, tomorrow gang raping a woman in a bus, and thrusting an iron rod into her private parts and tearing her open and killing her there on spot, and then saying like, sir, I'm a juvenile, I will only stay in custody for 2 years and then look for another woman to rape. So therefore you have to have a strict regime. See, everything, the development of law is directly correlated to how the society behaves and how the society shapes up. But you have to have safeguards. Safeguards means that you can't convert the state into a totalitarian state. You can't have a police state. I mean, you can't. You have to respect the individual rights of liberty and dignity of individuals as well. And if you want to prosecute somebody, deny somebody's liberty, you better be working in accordance with law. Any other question? All right.
Yes,
Any
sir.
other question?
Yes, sir. Just last question, sir, because there are many questions, so I'll just take a last question. Sir, one question is this, sir, can you please enlighten about the steps which are undertaking while collecting digital evidence?
With what? While connecting digital evidence with what? Can you just explain me the question, because I couldn't comprehend?
So someone is asking about the steps which are taken while collecting any digital
Oh,
evidence.
collecting. Very good. Collecting. Yeah, that's very important.
Collecting.
So confusion. Collecting. While collecting, collect original evidence, primary evidence. Don't run here by pen drive मिल गई भाग जाओ. So when you are collecting evidence, so somebody says, look, how do you collect? Say now, say for example, you're looking at the cops have a permission from Home Secretary to tap my phone, right? So I don't know my conversation is getting tapped on a digital device, correct? But the cops would be also under an obligation that you collect by phone, seize it properly, yeah, then correlate your digital evidence. So search and seizure means first you look for original and original alone. Second is once you found the original, you send it to a forensic laboratory to certify that the piece of evidence you want to prove against the accused is verified and certified to be correct. Then you maintain a proper chain of custody. ये नहीं है कि सील ही फटी हुई है, कल को तो मैं बोलूंगा सर सील फटी हुई है और इसका तो कोई भरोसा ही नहीं है, सही है गलत है, हो गया कोर्ट में उधर ही डिसबिलीव हो गया. चेन ऑफ कस्टडी इज वेरी इंपॉर्टेंट. कलेक्शन ऑफ प्राइमरी एविडेंस इज वेरी इंपॉर्टेंट. फोरेंसिक सर्टिफिकेशन इज वेरी इंपॉर्टेंट एंड देन यू प्रूव इट इन द कोर्ट. पता चल गया कि साहब माल खाने में तो जो है फोन जो है चूहा खा गया, उसको प्रोटेक्ट भी करना है. So tomorrow, if you have taken all steps, but in a court finds that the seal is broken, your case is gone. Tomorrow you have to effectively play it in a court of law also. For example, let me give you an example of Parliament attack. In Parliament attack, there was a conversation which was being relied upon. When it was played before the court, there was so much noise that the court could not hear what the people were talking, although there was a transcript. So prosecutors were banging their heads. I remember in High Court of Delhi in Division Bench number 2, the famous Mr. Gopal Subramaniam, senior advocate, who once was slotted, one of the most legendary lawyers in India. Every lawyer looks up to him. Now a Queen's Counsel in England as well. He hammered his head. Sir, this conversation has taken place. Justice Usha Mehta said, sir, I can't even hear what they are saying, Mr. Subramaniam. How do I rely upon it? I have heard enough. Thank you. Dismissed. That's what happens. तो कोर्ट में भी कल आपको वो डिजिटल एविडेंस प्ले करना है. अगर व्हाट्सएप है कोर्ट को दिखाना है, अगर कॉन्वर्सेशन है तो कोर्ट के सामने प्ले करना है. ये नहीं आप उसमें से 1 सेकंड प्ले करेंगे, पूरा प्ले करना. यू कैन बी सिलेक्टिव. अगर मैंने 1 घंटे बात करी तो पूरे घंटे का कॉन्वर्सेशन चलेगा. अगर बीच में वो टूट गया या कोई बीच में गैप आ गया, जज बोलेगा थैंक यू, उसका नोट बनाएगा, फाइनल आर्ग्यूमेंट बोलेगा ये रिलायबल नहीं है. That's how you collect evidence and preserve the originality. Emphasis is on to preserve the original evidence, to produce it in the original form, and to convince a court that it is free from any kind of adulteration. Then the court can act upon it. Any other question?
Sir, last one. One boy, someone has typed over here. So this is the last question.
Oh, which confession statement is stronger, either the confession given at the police station or confession given at cyber station? Both are inadmissible in a court of law, my friend, till we have section 25 of the Indian Evidence Act. Because the confession before a court, once a person is in custody, is inadmissible in law. When does a confession become admissible? When the person says, look, I am willing to confess my guilt, take me to a magistrate, he will record a statement under 164. He will give me a warning that भैया ये statement कल आपके खिलाफ अदालत में यूज किया जा सकता है, बराबर होशो हवास में होगा. जी हाँ हुजूर हूँ, अच्छा बताइए क्या कहना था. और an extra judicial confession में किसी जगह और कह दिया, वो आके गवाही देने लगा. So till at the end of the day you are having a confession, but that confession is given in when you are in custody. Say tomorrow a confession is digitally recorded. आपने आज की डेट में तो हर पुलिस वाले के पास में कैमरा है. हाँ भाई बोले यार तूने कैसे मर्डर किया? सर मैंने ऐसे किया, ऐसे किया, ऐसे किया, ऐसे किया, ऐसे किया. Court will still say this is inadmissible because the court does not know that whether this man has given this statement under coercion. भाई आप बाहर किसी को पीट लो, उसको आपने धो दिया और उसको बोला भैया आप अंदर आएगा और साफ साफ बोलियो मैं रिकॉर्ड करूंगा, नहीं तो बाद में तेरे को और मारूंगा. That's why court rejects it. So you have to have substantive changes in the legislation. You see now Supreme Court is cognizant of this fact. Whether all the statements that are recorded by the courts during the course of investigation should be digitally recorded. The court is seized of this issue and lawyers are appearing. I am also appearing in one of such cases. And I'm in for it, because most of the time what happens is you record a 161 that is not signed by the person. Tomorrow a person goes hostile. Let me give you an example. In Sorabuddin Sheikh encounter case, the SIT and the CBI was trying cops who raped and murdered Sorabuddin's wife, Kausarbi, murdered Sorabuddin Sheikh in an encounter beyond the due process of law, and also killed and murdered Tulsi Ram Prajapati, rather than bringing them to the book for whatever allegedly they had done. And they've brought more than 100 witnesses. All of them went hostile on their 161s. Nobody's 164 statement was recorded. And the cops got an equity, whether it was Sangyan, Pandian, or some Manzara, although they remained in custody for 6 years, but the trial became a joke. Why? Because you did not secure your statement. See, tomorrow, if the statement of a witness under 161 is digitally recorded, the court can say, कि भैया आप तो नया ही गाना गा रहे हैं, क्या बात है? ये देखिए पहले तो आप ये बोल रहे थे. So you have to have substantive legislation, properly. You have to make amendments, and you have to say that then a person can be confronted with his previously digitally recorded statement. But वो digital recording भी आपको जो है भी कानून अनुसार ही साबित करना पड़ेगा. दूसरा आपको ये भी देखना पड़ेगा कि साथ जो गवाह बयान दे रहा है वो कहीं दबाव में तो नहीं दे रहा. So there are so many ramifications in a court of law. Ultimately, what does the court look for? Simple 2 words: cogent and convincing evidence, either given by prosecution or given by defense in order to deduce a fine. Is that all?
Yes, sir. That's all.
Okay.
So finally, we come to an end to a great webinar session and an interesting talk by Tanveer sir. So here we have a final webinar tomorrow on domestic violence. So you can join us on the same time. Thank you so much once again, sir, for being a part of today's webinar. It was really very great having you today. So on behalf of Manav Soni and Tanveer sir, we thank you all for being a part. So till then, take care, stay safe, and have a really great day ahead. So we are signing off now. Thank you. Thank you,
I
sir.
wish
Thank
you
you.
all best in your careers, best in your college, and best in your professional life. If at any point of time any student, any young lawyer wants to get in touch with me, Manav, give my number, give my email. Anybody wants to write an email to me, ask a question, ask a query, you're welcome to do it any point.
Sure.
I hope
Sure.
all you guys found whatever I talked as useful, and it has invigorated your sense of how evidence is proved in a court of law. It's all about getting your basics right, and you have to, if you are a batsman and you are number 1, number 3, if you do not have basics correct, you can never score 100. So
Yes.
the idea is to get your basics right, and then you can go and play a big innings. Ramjit Malani was not a living legend of criminal law, not for nothing. He knew his basics very, very well. That's why he was a sound criminal lawyer and one of the best trial lawyers in India. Unfortunately, he's no more, but his legacy goes on. I had the privilege, to share a platform with, Ramjit Malani Saab in the 2G Spectrum trial, where he used to represent one accused and I used to represent another accused, and we did cross-examinations together. That I consider as a personal privilege for me in my life. But there are many more miles to walk. So I wish you all guys the best of luck, and I hope that all of you achieve what you have dreamt. And let me tell you that you should first have the ability to dream, and then your dreams will come true. Secondly, you must kill your inner fear. The biggest ability of a person is in anywhere, in legal career or otherwise. A person always has a fear, whether I will succeed as a lawyer, whether I will succeed in the profession, whether I will succeed in my love or in my marriage, whether my girlfriend will run away or something of that sort. So you have to kill your fear. Be fearless. And in a court of law, you are under an obligation to assist the court. You should never refuse a brief. And if a poor man comes to you, you should not say, get out, you're not paying me any fee. हर किसी का केस लड़ेगी और कोर्ट में अच्छा काम करे. So I will wish you guys all the luck. Thank you very much for attending today's webinar. And Manav, give my regards to your dad also. And tell
Sure,
him that he's free to give me a call anytime. I'll log out.
sir. Thank you so much, sir.
Bye bye.
Bye.